What's going on, guys? It's your girl Angie Snatch coming at you with another episode of An Unbiased Truth. And today I have an update in the Grandmaster Jay federal case. They have set a trial date. There will be a jury trial. But I believe that all of this is just to disarm Grandmaster Jay. They do not want him to possess any firearms. And I will show you why. First, let's get into the state case because the federal case is where they set the trial date with the jury. The state case is where they have a status conference set for December 1st. The state's case is the wanton endangerment charges, 5 counts of wanton endangerment. Wanton endangerment is defined under Kentucky law as engaging in conduct that creates a substantial danger of serious physical injury or death to another person. The statute also states that the conduct is under circumstances that manifest an extreme indifference to the value of human life. First degree wanton endangerment is charged as a Class D felony. A person could be sentenced to up to 5 years in prison and receive a fine of up to $10,000 for a conviction. So he would be facing 25 years if he was found guilty of all of these charges. These charges need to stick in order for the state to have count two of their case, which is brandishing a weapon while in violation of a crime. Wanton endangerment would be that crime. So, like I said, they went into now we have the status hearing update for December 1st. That will be in front of Judge Annie Connolly, and I'll bring that to you. But I want to show you what I mean when I say that they really just want to get all of his guns. So this is the joint status report for how the trial will work. Both the plaintiff and the defendant, they have agreed to this and they submitted to the court. So they're expecting that the length of trial will be 1 week. The proposed expert disclosures will have to be turned in by February 1st. Proposed MIL, the final pretrial conference is the week of April 4th, and then March 28th. They didn't do this in order at all. But March 28th, the pretrial memorandums are due, any specific jury instructions, the voir dire, and the proposed trial dates proposed. So this could get pushed back, but this is agreed to by both parties. The proposed trial dates for the federal trial will be April 18th through the week of April 25th. Now let's get into me saying that they want to disarm him. So in the original indictment, they filed a notice of forfeiture of weapon, because remember, part of it was that he had to forfeit some weapons. So if you look at the bottom, it says all firearms and ammunition involved in the commission of the offenses, including but not limited to the Delton Inc. DTI AR-15. This is with one magazine. So this is specifically what he forfeited over to them. Now fast forward to this agreement, and now in November 18th, now the government is coming back with more weapons that they want Grandmaster Jay to forfeit. Sidebar, he puts my little 380 to shame. So I'm gonna read off a list, and you'll see the pictures on the side of the screen. They get a little more information of what weapons they're specifically talking about. So the Smith and Wesson P15 22, the Radical Firearms Model RF15, the Anderson AM 15, the Bushmaster. Oh, no, that's not the Bushmaster. Next, the Smith and Wesson M&P 15, the Bushmaster XM15 E2S, and all associated ammunition. So now they're asking him to turn over more of his firearms. Well, actually, in this, what they're saying is upon conviction, they will be asking for him to turn over these firearms. But for this charge, in this federal case, the charge only carries up to 1 year. And what it seems to me is that they have more interest in disarming him than thinking that he's a harm to society. I think that they are trying to disarm him not of just his weapons, but of his influence in that community, And when I say that community, that because he's almost a component of the NRA, just like a black component of the NRA. He really speaks about arming up, and I think that that is what they want to take away from him, that voice and that influence, because for this case, he's only facing up to 1 year. For the wanton endangerment charge, I mean, that's a stretch, because you're saying immense danger. You're saying immense immediate danger. But then part of the affidavit talks about that he pointed up and shined a light and then they backed up. So I'm trying to figure out where is the immense danger, because remember in the Breonna Taylor case, those officers were also charged with wanton endangerment. Sad part is it wasn't for shooting in her apartment; it was for bullets that went through the wall to neighboring apartments, and they were charged for wanton endangerment because it was said that they should have known by shooting into an apartment complex building into an apartment that there would be a likelihood that a bullet could go through a wall or that someone else would be injured. That's a far jump from at night someone pointing up to the roof. Now, could Grandmaster Jay had been antagonizing them? Could they have had the conversations that they say that they had, that he had conversations with officials there in Kentucky about holding the guns at low ready and all of those things? I mean, could he have been antagonizing him and he went too far? His arrogance now put him in this situation. And so now he's given them the perfect opportunity, the perfect excuse to now take away your power and your influence. Because remember, part of his release is he also cannot use his social media handles. I don't know. Tell me what you guys think. I wanted to bring you this update. So there will be a jury trial. They will have jury selection. That is going to be a 1 week trial, but they don't have to file anything till February. But on December 1st, we are going to watch the wanton endangerment status conference in front of Judge Ann Connolly. All right, guys, it's your girl Angie Snatch.